So the case that comes before us now is Robinson versus Shank, and each side will have 15 minutes to present their arguments. The appellant may reserve up to 5, so you just need to let me know if you want to reserve some time. And we are being recorded, so keep your voice up. You're going to be able to sit there and still be recorded, that's fine. And then when it's the appellee's turn, if you don't mind coming to the podium, and so we can hear you and see you better. Then don't mention the names of any victims or any children. I don't think that's relevant, but we'd like to say it all the time for any cases that are presented, just in case something would come up. Or, in all honesty, it's kind of like muscle repetition for our brains too, that we make sure we say it, and that way I won't forget whenever it's applicable. So anyway, we're ready to proceed. We've read the briefs, and we're ready to proceed for the arguments.
Your Honor, I'd like to reserve 3 minutes.
Okay.
Your Honor, my name is Attorney Robert Gargis on behalf of the landowner, building owner, Brian Robinson, in this matter. And I'd like the court to appreciate the fact that the lawsuit that was filed in the small claims court, was not actually served upon Mr. Robinson. In fact, the statutory agent for the LLC received the paperwork, but somehow or another, it was not provided to the managing partners. And in this LLC, 70% is owned by Mr. Robinson, and 30% is owned by his wife. And as I'm sure, as in the briefs, LLCs are separate entities from human beings, individuals. And what we have as error by the trial court is, despite the fact that he had no knowledge that this lawsuit existed and that a default judgment was taken against his LLC for the $6,000 and some dollars, okay, which, by the way, was recently satisfied by garnishment of the LLC's accounts. So, the LLC has paid the judgment debt against it, okay? And most recently, like in the past 3 weeks or so. So what we have left is the trial court saying, well, you should have brought this case in the small claims court. But the problem was that he didn't even know that he had a small claims case against his LLC, and he was never a party to that original case, never. So what does that tell us? Well, I cited about the fact that due process concerns under the federal constitution requires that somebody have notice, okay, before you can hold them responsible for a res judicata state argument. You have to be able to show that he had noticed that there was this lawsuit that was pending, which he never did. He didn't have an ability to participate in it. So when the judge's conclusion, in her opinion, where she says, well, you should have brought the case together. They all should have been brought together. That's a problem, because how do you bring a case in a matter that you don't know exists? And furthermore, okay, and even probably more important in my opinion, okay, because I have a little bit of a construction background, how do you know something's wrong until you actually have somebody come out and look at what was done and they say, hey, this is all wrong. This is what needs to be done. And that's what Mr. Robinson did. He actually had, and the lawsuit that was filed against the LLC in the small claims court, for that $5,000 car repair or whatever, has nothing to do with, the construction of this building according to codes. I mean,
well, but wasn't that part of their remuneration for this all? It was part of...
well, the LLC was supposed to. I'm not arguing that the LLC doesn't have a liability as established by the small claims court. And that's been paid and satisfied.
Right, but they're arguing you were in privity with the LLC.
Well, how can you be in privity with something that you don't know exists? And the defects that exist in the building, you didn't even know those existed until you had it come out. The guy built, first of all, he misrepresented himself as being a qualified contractor, okay? Well, he's not an electrical contractor, and he's doing electrical work, and there's, I don't know, $12,000 worth of repairs that have to be done, because the work was done without inspection, without proper qualification, and we go to the fact that he put up all this, you know, in the shop, you're supposed to have metal lines for pressure lines. Well, he put up plastic lines, okay, with like metal fittings on the ends. Well, OSHA says that's not allowable because they blow up, they're like bombs, okay? So this had to be discovered by experts coming in, looking at it, and saying, hey, this is all wrong, you can't do that. Chris Nyhart is also trained as a fire marshal as well as a building inspector. And for him to come in and say, hey, you got $21,000 worth of repairs that have to be made, you add it to the electrical repairs, I mean, we're way above, you know, the jurisdictional limits of a small claims court if we knew that the lawsuit existed at the time.
So my understanding, and I don't know if this is in the record or not in the record, but somebody in the App Police brief, I said that you did not file 60B to vacate the judgment in the small claims court for lack of notice.
I don't represent the LLC, and when I looked at it, and you know, the statutory agent for the LLC failed to give this, I didn't see how I could say to anyone in a court that 60B applies. There was no fraud upon the court. The negligence there was with the statutory agent. And, you know, the fact that he wants to get $5,000 or $6,000 is nothing compared to the $90,000 approximately that the damages were. So when the judge just throws Mr. Robinson as the owner of the building, okay, the owner of the building approved to allow for the tenant, the LLC, to contract, okay, but we did not have a contract. Mr. Robinson did not have a contract with Shank defendants, and that issue wasn't even brought up because, number one, he was never served. He was never a party to that case in the small claims court. And if he would have been served, you know, I think they were kind of slick with the way that they positioned this, because they knew that there were issues, you know, with their work, and that ultimately they were going to have to, you know, tone up for it. But the judge, the trial court judge, just lets them walk away. And that's, you know, we had this case 20 years ago in the Hamrick case, okay? I can't believe I'm back here 20 years later arguing the same facts in the delirious small claims court, saying, you know, we're barred, okay? And the insurance companies did the same thing, okay? Res judicata, res judicata. I like Kurt and his firm and everything else, but, you know, they're going to take every little possibility to try to prevent, you know, they're insured from having to be exposed. But that's what we got here. We got a guy that is unlicensed to do electrical work, not qualified to install, you know, the, I guess they call them pneumatics, you know, on the wall where the power wrenches and all that connect up to. He's unqualified to do that. And he has damaged and committed waste against the owner's property because of his behaviors.
Let me interrupt you just for a second. In regard to the court's dismissal of this or granting summary judgment under res judicata, did you provide evidence to the court that that your client could not have discovered the construction problems until after the small claims court?
Yes, Your Honor. It was in the affidavit of Mr. Robinson. And I believe that, I believe also the dates of the inspection reports from the professionals that came out are beyond the dates that this judgment was rendered. So I think, you know, of record, it should have been, besides us telling the trial court judge, you know, it should have been evident from the documents that were attached to the affidavit.
But was there evidence presented that these could not be discovered for some reason?
Well, you have to have somebody come out and do the inspection first.
Well,
and Mr. Robinson is an expert with respect to auto mechanics. You know, he could fix anything, you know, but he's not an expert in construction. And to prove that, you know, he went and obtained a structural engineer before doing anything to see if his building could even, because he wants to raise the cars up. And in order to do that, he had to increase the volume of the interior of his building. So he had to get a structural engineer to actually say to him, is this possible? And the structural engineer said yes. And that document that he obtained from the structural engineer was shared with the Shank defendants. So they knew, that this is something that could be done. And then they decided and misrepresented themselves as capable of performing that to the building owner, Mr. Robinson.
Counsel, was the construction all complete? Was everything done when the original small claims court was filed?
I don't think it's done today, Your Honor. I think it was stopped. I think it was stopped, and I don't believe it's completely finished yet today. In fact, I think a lot of these repairs, are going to have to be made by qualified people. And, it's like Mr. Robinson is a small businessman, and, somebody just takes $7,000 from your checking account, like happened to him in the past couple of weeks. It's not easy to recover from that. I mean, he doesn't have an unlimited personal supply of money in order to fund these things.
And that would have been from the LLC account, though?
Correct. The LLC is the operating business. That's correct. And that is the business that had a contract with the Shank defendants. The part, Your Honor, I think is very interesting relative to the United States Supreme Court rulings. Basically say the requirements of due process and in issuing a decision, your opportunity to be heard is an essential requisite of due process of law in judicial proceedings. And that's from federal United States Supreme Court decisions, which they say basically that even if a state allows for res judicata to be used, it can't be used in such a way as to prohibit an individual's ability to have their day in court. And I think that's what the trial court did here in this case. So we really would like to have our day in court. We would like to have the opportunity, to proceed. He had no knowledge of any small claims proceeding and was not even a party to the small claims court proceedings. So you can't argue that a guy can be barred when he doesn't have knowledge. You might be able to make the argument that, hey, there should have been privity here to be recognized. Okay, but you can't make that argument that he's prevented from having his day in court when he was never provided notice of the proceedings.
Counsel, you're down to your 3 minutes.
Thank you, Your Honor.
Thank you. And you have the full 15 minutes, and we're ready to proceed anytime you are.
Thank you, Your Honors. Kurt Anderson on behalf of the appellees, Richard Shank and Shank Builders. Your Honors, all these arguments are arguments that could have been raised in a 60B motion in the small claims court. The argument that, hey, somehow or other the service of the notice was duly made on the statutory agent, there's no doubt about that. But if in fact there was some kind of miscommunication in getting it from the statutory agent to the company itself, that's something that can be raised in a 60B motion. If in fact there was new evidence of things that were done incorrectly, at least they should have tried. There was nothing that they've ever attempted to do to overturn or to get their day in court on the issues in the small claims court.
Well, let's just assume, for sake of argument, that when the small claims court case was filed, that these issues with the construction had not been discovered, and were really not discoverable until, for whatever reason. They couldn't have raised them by defending in a small claims court at that time either, right?
They could have in a 60B motion, but actually, Your Honors, making the assumption would be contrary to the record. The judgment was issued in January of 2023. This lawsuit was filed in May of 2023. They had plenty of time to attempt to revisit the lawsuit, but instead they just simply ignored it. They ignored the judgment. So the criteria of res judicata, that there is a valid judgment on the merits against a party who has a mutuality of interest with the party who was actually the subject of the judgment on the transaction that was also litigated.
Isn't the mutuality of interest a factual matter? And this
But
is
there's no
some-
dispute about the mutuality in this case, because
Well, I haven't had the chance to review the record, but, the judge is saying, even though you weren't a party to this case, you had enough information, you should have done something.
that wasn't the reason for applying res judicata. The reason for applying res judicata was that Mr. Robinson, as the owner of the property, had a mutuality of interest with his LLC, an identity of interest, because they were one and the same individuals, okay? But leaving that aside, even if you had a different owner of the LLC, it would still be a mutuality of interest, because when a landlord authorizes a tenant to proceed with doing repairs and improvements on the property that the landlord himself owns.
Right, but it's a contract. Was there a allegation anywhere in the case that Mr. Robinson entered into a contract with Shank?
That Mr.
As
that
an
is not,
individual?
that is not the privity test that is at issue. That the privity of the privity of contract is not the privity that is being discussed in a res judicata case. This is a party that has a relationship with that same party that was in the litigation that is so close as to essentially be in the same shoes on that same issue. So the privity is an analysis of what is the relationship of those two parties and what is their interests, their mutuality of interest in that litigation.
So are you telling me there's no dispute at the trial court level between Robinson and Shank that there's that mutuality of interest means that they're one and the same?
Let me read you from the complaint itself, which I thought I had. Yes, here. Paragraph 3 of the complaint. The owner and tenant acquired an engineer's report on structural feasibility to perform certain repairs and improvements. They jointly decided to do this particular improvement. Paragraph 4, plaintiff owner consented to lessee's proposed improvements. He agreed, yes, let's do this. Now, keeping in mind that he's wearing essentially two hats himself, but even if you had two distinct individuals, the LLC as a tenant, him as the owner, it's still one and the same, because now the tenant becomes his agent for negotiating the contract.
Are there agency arguments that were made?
In so many words, I'm not sure that there were, but it was very clear that what was being argued is that they had a common interest. They had a mutuality of interest. And in fact, the complaint and the affidavit that Mr. Robinson submitted in opposition to summary judgment, he says, Shank violated duties that were owed to me as the owner by virtue of the fact that he did not perform his contract with the LLC in a workmanlike manner. He's putting himself into that contract and saying, in the performance of the contract, even though it was with the LLC, I had a vested interest. Absolutely, that's exactly what mutuality is that you guys are both in the same shoes. I mean, very literally standing in the same shoes, okay? But in the same sense that there is a common interest. And in doing so, he has essentially appointed the LLC as his agent for negotiating the contract. I think it's very relevant when he makes allegations about fraud. Well, he said that he was qualified and capable. the affidavit says, that allegation was made, Mr. Robinson's affidavit, he says that allegation was made to me personally. He was personally involved in the negotiation of that contract. And whether it was with him or in name in the LLC, the fact that he had a vested interest in that by virtue of his ownership of the property means that he and his LLC had a privity of interest, a mutuality of interest, a joint common interest.
But when,
Absolutely, we totally agree with that.
when Shank filed the lawsuit, it only filed against the LLC, not against Robinson.
Correct, because that's who his contract was with. And in fact, Mr. Gargas has admitted that right here. The contracting parties were, and in fact, if you take a look at the complaint doesn't assert a breach of contract claim. Why? Because the contract actually was with Shank and the LLC. What they are trying to do here is relitigate the contract in a tort framework, even though the contract was already litigated. And that's exactly what res judicata is all about. When that transaction has been litigated, it is binding the final judgment, which is undeniable that there is a valid final judgment on the merits. That final judgment on that contract is binding not only as to the party in the case, but also to those who are in privity with that defendant, meaning that they have a common interest, a mutuality of interest. And that's exactly what has happened in this case. And so, based on that, summary judgment was properly rendered on the grounds of res judicata, and we would ask the court to affirm it. I should point out, strictly speaking, in terms of appeal, the assignment of error was that there were genuine issues of material fact that prevented summary judgment. But in fact, nowhere in the appellate brief is there ever an identification of what those supposedly disputed facts are. There aren't any.
I was just gonna ask you about the summary judgment proceedings. What did Shank produce in regard to evidentiary materials?
We referenced the complaint, which is proper Rule 56 evidence. We attached certified copies of the small claims docket, complaint and judgment. And we attached Mr. Robinson's answers to our discovery request, including interrogatories and requests for admission. And in the request for admission, he admits that he was the real party in interest with regard to the work that was being done in that contract. And if you take a look at Mr. Robinson's own affidavit, where he says, in paragraphs 26, 27, 28, he says, that Shank breached duties owed to me, which in paragraph 21, he says, they failed to accomplish the lessee's contracted improvements in a workmanlike manner. So his own affidavit puts himself into that contract and saying, the contract may have been with the LLC, but you owe duties to me. Turned the other way around is that I have a mutuality of interest in that contract. That's exactly what we're arguing. So his own affidavit in opposition to summary judgment actually confirms the application of res judicata because he admits the mutuality of interest. The due process argument was never raised. There was never any mention of due process in the trial court. But for all practical purposes, the due process argument is simply res judicata in the rearview mirror. That if you apply res judicata incorrectly, then supposedly you have deprived me of due process. But the fact of the matter is that the due process would have occurred in the trial court, in the small claims court. That was their opportunity. And if they thought that it was unfair, that there was something improper about the notice, then it should have been raised there. And it could have been, but it never has been. So that was their day in court. There's nothing unfair about affirming a decision because, as you know, finality of decisions is important in our judicial system. So for those reasons, we think that trial court's entry of summary judgment was appropriate, and we would ask you to affirm. Thank you.
Thank you. You have 3 minutes.
Thank you. You can't file a $90,000 lawsuit in small claims court. And for him to suggest that that's what we should have done, well, that would have been just wonderful. We'd have been a laughing stock with everybody. So you don't do that. Number 2, okay, you have to know that it exists before you can file it, okay? And it's very clear. My client, Mr. Robinson, the property owner, he didn't know that there was a lawsuit pending in the small claims court until after the judgment had already been issued against him. And then he learned about all the bad things that had been accomplished to his building. Waste. And as far as duties owing, any contractor has duties owing to every citizen. If he does any kind of work, he owes duties to not only conform to the city codes and requirements, be a licensed contractor, be a licensed electrical contractor, not engage in creating hazards that have been referenced by OSHA to be bombs where people have been hurt, not only employees, but also customers. And that's what this guy, Shank, built. So, yeah, there's duties that's owed to him. And yeah, let's take a look. You can read the whole complaint. The whole complaint shows that he had duties owed to him that were violated by the way that his tenant's contractor screwed the job up.
Counsel, what did you put in for evidentiary materials in regard to response to summary judgment?
Expert reports verified by the affidavit of Mr. Robinson. The OSHA, I believe there was attached the OSHA documents that showed that this installation essentially has been outlawed, as being dangerous.
Was there anything in those affidavits that indicated that they were not discoverable before the time he filed suit in common police court?
Other than the dates on the inspection reports, Your Honor, that showed the dates that they were there.
Is there some reason why you can't file for 60B in the small claims court?
Well, it's beyond 1 year. It's beyond 1 year from the day of that judgment, and the judgment's moot because it's been paid by garnishment. They took, I believe, up to, I'm not sure, just under $7,000 from the LLC's account, against whom the judgment was rendered.
The only reason I'm asking this is because it sounds like this is a case that should have gone to mediation. Have you not done mediation with our court?
No, there's been no attempt at mediation. The trial court judge wrote a scathing opinion on a 12C motion. She didn't care for my language or my brief. And then she converted it over to a summary judgment motion. And then she decided everything and canceled all further proceedings.
All right, you are out of time, and the court will take the matter under advisement and issue an opinion that will be sent to both sides, as well as it will be released on the Supreme Court website electronically too. And